I'm going to choose to focus on case law and the facts that aren't presented by the defense. We see in their motion there's a grand claim that there's extraordinary evidence that John O'Keefe went into 34 Fairview that night. That is critical because there is no basis to accuse somebody of murdering another person if they don't have the opportunity. In other cases, a third-party culprit is not necessarily found at the scene, even in Finney. It's more than just a couple of derogatory words. In Finney, as counsel knows, there was a neighbor who had an axe or a club. He was seen with blood, went home, washed his clothes, wholly irregular, and because of this irregularity in the timing, he was then asked by his then wife about the victim, and he made a number of derogatory comments about her, showing ill will, evidencing, tangentially, motive. And so no, a third party does not necessarily have to be at the scene at the time the police investigate, but they have to be with the deceased if they caused the death. It's obvious. And so we didn't hear any extraordinary evidence, none. We didn't hear kind of good evidence. We didn't hear any evidence. We just have the bald assertion that the data forensic evidence will show that he was in the house. It didn't. It doesn't. They don't have a proffer. So there is no opportunity to murder John O'Keefe when all the evidence points to him dying on the front lawn from an alleged collision. The defense's effort to tell a story, take a couple of facts, someone's a boxer, they drank alcohol, and convert it into a story, is how they will try to portray these unsubstantiated facts at trial. They'll tell a story. It will divert the jury's attention. So they're not entitled to it. They're not entitled to it. Time-honored tradition, yes, but there are limitations. Silva Santiago was very clear about the limitations. This latitude is not unbounded. Each of these limitations recognizes the admission of feeble third-party culprit evidence poses a risk of unfair prejudice to the Commonwealth. I'm not whining. The Commonwealth should not be unfairly prejudiced. The people of the Commonwealth should not be unfairly prejudiced because it is inevitably, it diverts jurors' attention away from the defendant on trial and onto the third party. Essentially, it requires the Commonwealth to prove beyond a reasonable doubt the third-party culprit did not commit the crime. If there was evidence of third-party culprit, the defendant should be entitled to use it. In this case, there is not. There is no motive. There is no motive. To suggest that one person was pining, although the text messages don't show that, they both stopped corresponding with each other days before. To suggest that Mr. Albert is friends with Mr. Higgins and therefore he is bootstrapped into a conspiracy to kill with no evidence. Certainly the defense can infer certain facts like getting rid of the SIM card in a way they want, and I don't begrudge that at all. There's different interpretations to it. I understand that. This was heavily considered in the federal investigation, and after that absolute thorough investigation, there were no charges. There was no evidence of third-party culprit. There were no indictments. And so, although we don't know the parameters of the federal investigation and we can only guess as to some of it, we know from what we did receive and review, it was thorough. And if there was third-party culprit evidence, we would expect that there would be a basis for it. It's not an entitlement to simply bring it in under Bowden. I don't defend that there was commentary in the officer's phone that was inappropriate. But that doesn't automatically create a situation where there is evidence that the police officers knew that there was somebody that should have been investigated. In fact, when Mr. Albert came down the stairs, the testimony is the police officer was already inside his home. There's no evidence Mr. O'Keefe, a first responders, was still outside that aid could have been rendered. That is just, it's not only speculative, it's just piecing together different facts and telling a story. So inevitably, while I recognize the case law, there are plenty of cases that talk about third-party culprit should not be admitted if inappropriate. Commonwealth v. Stedman. In that case, a person, not the defendant, was in a fight with a person at a campsite. And then later the defendant supposedly went back to the campsite, a friend of this person, Royal, and used a knife to stab and kill him. And the defense wanted to introduce prior convictions about the fact that this supposed third-party culprit had attacked people at other homeless sites. Pretty close relationship. A person having a history of attacking people at homeless tent sites. And the court, looking at 403, did not allow it as third-party culprit. They said that the admission would be feeble, pose a risk of unfair prejudice. In that case, there was third-party culprit admitted pursuant to Bowden in a very different way. Commonwealth v. Moore. The court would not admit layered hearsay showing different identifications that were relayed by the police from third parties regarding a culprit. They said that the hearsay was uncertain, the source is unreliable, and it was inadmissible as third-party culprit. So it is not an entitlement to be third-party culprit. Commonwealth v. Buckman, 461 Mass. 2011. The defendant was charged with murdering his wife. When they received a report from one of the defendant's friends, the defendant was softly tied to a pole to look like he had been kidnapped. Inevitably, the police determined that he had help or tied himself as a ruse. And this person, the helper, his friend, had connections to gambling, was there, and when the police couldn't find the body, he knew exactly where the body was. That case is far stronger than many. And in that case, no motive, no intent, and they did not let a third-party culprit defense go forward. Facts suggesting that one side believes a person's telling the truth or not is not facts of third-party culprit. It's just not here in this case. And again, I iterate my position on denying the defense to cross-examine witnesses about these generalizations and these character attacks. I think it will mislead the jury, and it will become a total diversion for the jury, and I don't think the basis is anywhere close. It's feeble.
Briefly respond. Thank you. First of all, Your Honor, speaking about the federal investigation when you were not a part of it, and talking about why a federal grand jury was convened, what they were investigating, what they found or didn't found, is complete speculation. It should not be a part of this argument. We don't know. It didn't prove anything. It's not as though they came up with a statement exonerating anyone. So that should not be considered by the court. With regard to the two cases that Mr. Brennan cited, you'll note that in one, he talked about the exclusion of hearsay evidence. There's a different standard when you want to introduce hearsay evidence as part of a third-party culprit defense. There need to be substantial connecting links to the crime itself. The court ruled in that case there weren't. In Finney, there were. And with regard to the other case, that's with regard to hearsay. With regard to the other case, that was the exclusion of past assaults to show that somebody was violent. Again, Commonwealth v. Conkey is a case where they said, well, that should be, in addition to a normal or a regular third-party culprit defense, you should also be entitled to that evidence. So that's not very instructive. The other two things I just wanted to point out, because I did not mention them, Your Honor, is that Brian Albert also disposed of his phone, and we'll never know what was on that. That's further evidence of consciousness of guilt. And then an important point is that the plow driver, Mr. Loughran, went by the house at 3:30 in the morning and saw a Ford Edge parked in the very area where John O'Keefe's body was found. And we know from the evidence that the Alberts, both Brian Albert and Colin Albert, owned a Ford Edge. So that is in the mix as well. And unless the court has any questions, I would yes on that.
All right. Thank you very much.
Thank you.
So let's go on to paper 620, the Commonwealth's motion for production of records regarding Unsolved Productions.
May I?
Yes.
Your Honor, the Commonwealth filed a Rule 17 motion for records from Unsolved Productions. It has been discussed briefly in court at times during argument. There was a so-called documentary that was aired in a 5-part series. It gave a inside, behind-the-scenes look of the defense team and Ms. Reed as it prepared for the last trial. This 5-part docuseries produces a number of statements from the defendant, many of them extraordinarily relevant, some of them from the Commonwealth's perspective extraordinarily incriminating, and many of them inconsistent with statements made publicly in the past, including Dateline 2020 into Gretchen Voss. We served the local service in Boston, a local agent. The record holder is the producer of the series, and they have been notified. If the court allows this motion, I expect they will provide the information to us by the end of the week. I understand there is probably over 200 hours of recorded interviews, and we expect to use a number of those statements at trial. They are statements of the defendant, they're admissible substantively, they're admissible as admissions, and they're admissible to show contradictions with other statements. And so they are material and relevant. I understand the time frame. We haven't had the privilege of seeing them. The defense was there for a part or most of it, but we will use what time we can to sift through it. We're not looking for a continuance or additional time to look at the materials. We'll look at them as we prepare for trial. And so I'm asking you to grant this. It clearly makes the Rule 17 standard material relevant. We don't have access to these before trial. We won't be able to prepare for them if we get them pursuant to a trial subpoena. They've been properly subpoenaed and they are forthcoming with the court order.
There's no one here from Unsolved Productions opposing this today.
There is not.
Does defense want to be heard at all?
Your Honor, we're unaware of the communications back and forth between the Commonwealth and the production company, so we've not been privy to that. This is the first that we're hearing of any communications that they've had with the production company. I think obviously in an abundance of caution, they should be given an opportunity to oppose if they wish. Nothing official has been filed one way or the other. So we're not in a position to argue on their behalf, for sure.
All right. So, we have two things left to discuss. I want to talk about jury impoundment. We also have a Commonwealth motion regarding Mr. Yanetti's claim. Mr. Yanetti, it's 10 past 12. Which one do you want to go forward on first? Do you want to talk about the impoundment, or do you want this motion?
I'm not handling either of those.
I understand, but do you have a preference what's done before lunch? All right, so let's do that motion. Commonwealth's motion to compel communications between the defendant and the attorney. Stored within the defendant's document.
Your Honor, so I'm clear, the Commonwealth is not seeking all communications between Ms. Reed and Mr. Yanetti. We're only requesting the communications that may be on any type of records in the possession of the Commonwealth. And specifically, there are phone records which have been redacted, and I do not know what is underneath those redactions. And we believe we have an entitlement to the information in the narrow area where Ms. Reed has waived her attorney-client privilege. Specifically, where the defendant intentionally divulged the content of her communications with Attorney Yanetti about liability and potentially striking John O'Keefe with her car. Those subject areas in that narrow time frame are no longer privileged because they're now public. The Commonwealth has identified a very narrow window, and that's a 3-day period. And that is what is mentioned by Ms. Reed in her public statements, that she spoke to Mr. Yanetti and she thought about it for 3 days. We're not looking for any information beyond what has been waived. We're not looking for any information on collateral issues, and that's why we suggest that the court look at those records in camera, and the court makes the assessment whether or not the area in which where Ms. Reed waived her attorney-client privilege, whether any of those materials would similarly be waived because they are exactly related. This is made in good faith. Anything that is non-privileged is open to the public. It's not confidential. There are 2 communications that Ms. Reed made publicly that we assert waived the attorney-client privilege as it relates to that issue. Ms. Reed had an interview with Gretchen Voss on June 20th, 2023, and the transcript is page 105, line 23. She was asked the question by Ms. Voss, "You never said, 'Did I hit him?' I hit him." And the answer by Ms. Reed was, "I said, did I hit him? Question mark. And then, when I talked to David," now this is later, David said, "Karen, if you incapacitated him in any way, there's culpability there." And I thought, all right, maybe this is what, maybe I said to my mother, just to go forward for a second, they were asking me, what was it like? Did they come out? What was the house like? Similarly, in the documentary series, Ms. Reed is video and audio taped, and it was presented on television, that she said, "And then when I hired David Yanetti, I asked him those questions the night of January 29th, like, David, what if I ran his foot over, or what if I clipped him in the knee, and he passed out or went to care for himself, and he threw up or passed out?" And David said, "Yeah, then you have some element of culpability." So that's how I thought about it for about 3 days. And so that is where I get the time period regarding these relevant statements, admissions by the defendant about her state of mind and her interaction with John O'Keefe in her vehicle. These statements were made during conversations that are obviously no longer protected or private or privileged. They're no longer confidential because they've been intentionally disseminated to the public. And so the defendant has voluntarily waived that privilege as to these communications in this subject area in that time period. And the key, Your Honor, is that it is the defendant herself who made the communications confidential. Even if it was inadvertent or overheard, it would still waive the privilege. This is entirely different. There can be no doubt that there was an intention to pierce that attorney-client privilege for whatever benefit the defense thought it gained them. This was intentional. It wasn't secretive. It wasn't overheard. It was a exacting and purposeful engagement. So we ask you to review the cell phone extraction, any texts or emails that may be on those extractions, and relative to that short window, relative to this specific area, anything that is waived that is no longer confidential, we believe we're entitled to. It obviously would be relevant if it's narrowly related to these statements, and we would use that at trial. Thank you.
I am, Your Honor. May it please the Court. The Commonwealth concedes throughout its motion, as it must, that the communications it seeks to intrude into are privileged communications between Ms. Reed and her attorney, Mr. Yanetti. 2 of the 3 instances of the communication they cite to are over 9 months old, and that's in 5 months old respectively. So you have 9 months ago the Gretchen Voss statements, and 5 months ago the Vanity Fair statements. But they waited until less than 2 weeks before the start of the trial to bring this momentous and potentially far-reaching and consequential motion. Why? The courts are clear that they take an extraordinarily dim view of parties waiting until moments before trial to raise significant issues like privileged communications this close to trial. The Commonwealth does not explain their delay in raising this issue this close to trial. With regard to the 3rd communication, the HBO Max one, it regards the same event that is discussed in the first 2. There is no addition of an event in the 3rd one. So that 3rd discussion, the docuseries, regards the same events that have been extant in the first 2 that have been extant for 9 months and 5 months. The depth of this attempted intrusion by the Commonwealth should disturb and unsettle every citizen of this Commonwealth, because they're either actual or potential clients of lawyers, and it should unsettle every criminal defense attorney in this Commonwealth, and I would dare to say it probably does. As we know, texts, emails, and written communications, exactly what the Commonwealth is seeking here, between an attorney and their client, are canonical examples of privileged material. So what is at stake in this motion? What is at stake is the sacrosanct attorney-client privilege. In Upjohn versus United States, the really bedrock attorney-client case from the U.S. Supreme Court, it established that dating at least from the age of Shakespeare, the attorney-client privilege is the oldest of privilege for confidential communications known to the common law, and this Commonwealth has identified that it is one of the most important, and it's been recognized in the Commonwealth as early as 1831. And in the context of criminal circumstances, the privilege has constitutional dimensions as well as it affects the interests of justice analysis that is documented in the Commonwealth v. Goldman case 395 Mass at 502. And it bears underscoring the basis and the depth of the intrusion is a quote from the very case and the only case that the Commonwealth cites in its motion. It cites one case in its motion for all of its propositions. Just one. Matter of a John Doe grand jury investigation, 408 Mass 480. In the case at 485 states, as we have indicated, extraordinarily high value must be placed on the right of every citizen to obtain the thoughtful advice of a fully informed attorney concerning legal matters. A rule that would permit or require an attorney to disclose information given to him or her by a client in confidence, even though such disclosure might be limited to the period after the client's death, would in many instances, we fear, so deter the client from telling all as to seriously impair the attorney's ability to function effectively. We think that the potential is inconsistent with the traditional value our society has assigned. Here's a key point. In the interests of justice, and that's the rooting of the interest of justice analysis, to the right to counsel and to an effective attorney-client relationship. Therefore, except where mandated by constitutional considerations, and it cites C. Commonwealth v. Goldman, Super 395 Mass at 502, which are not a factor in this case, nor are they a factor in our, not a factor in that case, we conclude that the attorney-client privilege should not yield either before or after the client's death to society's interest as legitimate as we recognize that interest in obtaining every man's evidence. So the case the Commonwealth cites supports the protection of the attorney-client privilege. With that law jurisprudential predicate in mind, I now turn to the statements at issue here and their import to that analysis.
You know what, Mr. Leslie, I'm going to stop you. I understand the Commonwealth's argument regarding waiver. I understand that the request is narrowly tailored. I'm not going to need to give you this information, Mr. Brennan. I don't even think it's appropriate for me to ask, so the motion is denied.
Thank you, Your Honor.